Good morning and welcome to Employment Hour in 30. I'm John Scholes. He is Lior Samfiru from the Samfiru Tumarkin law firm. We do this each week. We talk about your employment rights. Contact is easy, 1-855-821-5900 and help at employmentlawyer.ca. Lior, big show again this week. Lots of stuff to cover, including the week that was. It's always how we start. And of course, severancepaycalculator.com. You'll want to find out exactly what your severance should be, the true number. We'll dig a lot deeper and we'll unpack a couple scenarios in that regard using the Severance Pay Calculator. But in the meantime, you'll want to check it on your own. Severancepaycalculator.com. What do you got going on today, pal?
Well, you know, I have a lot going on pretty much every week. Speak every week with a lot of people about their workplace rights, workplace problems, and it's exciting. It's a great time to find out about those rights. Every week here right on the show, we talk about the problems that people may have in the workplace and how to solve those, what those means, and what rights people have. So if you haven't watched our show before, tune in. Every week we'll try to inform and educate and give you some more quivers, so to speak, in your armor there, so that you can you can use that to your advantage. You can use that when you have a problem. You'll know what to do. You'll know what to say if you have any workplace issues. And we always like to start off the show with the week that was, talking about a couple, or at least one scenario that I saw over the past few days. So in this situation, I got a call from a lady that was recently let go. She had worked for a year and a half in a company's accounting department. Regular job. She was an independent contractor. More about that in a second. Unfortunately, fairly recently, she was diagnosed with a serious medical condition, and she had to take some time off work. She'd been off work for about 3 weeks, and it wasn't clear exactly how long she'll be off. Hopefully not too long, but she was getting doctor's treatment. Well, while off on a medical leave, she got a letter from the company saying, given the fact you haven't been here, we're letting you go. Since you're an independent contractor, we don't have to pay you anything. We wish you all the best in the future. And obviously this was a shock for this lady, and she called me and she wanted to know, is this right? Do they do the right thing? And what can I do? Well, let's unpack this. First of all, she was not an independent contractor. She had a regular job. She worked for the company in the company's offices. She's been doing it for a year and a half. She went every day at 9 o'clock. She left every day at 5 o'clock. So even though they treated her on paper as an independent contractor, she wasn't. She was an employee. And I want our viewers to understand that it doesn't matter what you call yourself, what the company calls you, what agreement you sign, or who pays your taxes. If you have a regular job, you're an employee in the eyes of the law. So right off the bat, John, it means that when they let her go, they would have owed her severance. And after a year and a half, I assessed her as being owed 4 to 5 months of pay. So right off the bat. But beyond that, they let her go when she was off sick. She was off for a few weeks, serious medical condition. That's illegal. You can't do that. By the way, you can't do that even if she's an independent contractor. But it's a human rights violation. You cannot let someone go because they're sick. As simple as that. So in this situation, number one, it's a wrongful dismissal because she is an employee and she's owed severance. And number two, it's a human rights violation because they let her go when she's sick. So she has significant entitlements. So I bring this up here because our viewers may come across this often. Maybe a situation where they think they're an independent contractor, but no, they're probably not. They're really employees, which means they have the rights of employees. And beyond that, you always should know that if you're sick, you should have the ability to get better, the ability to take time off without being fired, without being penalized. If you have a doctor saying you need to be off work, you can be off work, and your employer, John, can't do anything about it.
And I know a lot of the viewers right now are probably thinking, wow, he just said independent. I assumed I'm an independent contractor. They should contact you because they might not be, right?
Yeah. If you're even 2% in doubt as to whether you're an independent contractor, you're not an independent contractor, okay? You know, what's the example I always use? The plumber or the electrician. Those guys, the electrician you call into your house to fix an electrical problem, he's an independent contractor.
Right.
Because you're not his only customer. He would go, after he's done with your home, he's going to go to another home, and he's going to market his services because he's in business for himself. So the independent contractor is someone like the electrician. But if you have a regular job, you go to work, you work for someone, you are an employee, full stop. It doesn't matter what you call yourself.
If you don't know for certain, make the phone call, 1-855-821-5900, help at employmentlawyer.ca, employmenthourtv.ca as well. You can go to that site anytime. There you will find out how you can catch our weekly radio shows. I said shows because we do so many now, and they're on all the time. During the shows, of course, it's radio. We get a ton of phone calls, and I want to play a phone call back and have you comment on it now.
I worked 25 years for a large manufacturing company, and I had a nervous breakdown. I was called in to sign an agreement for 8 weeks and 2 weeks let-go pay. Does that sound right? Or I needed the money, and I needed medication and stuff.
Yeah, well, you know, it's an unfortunate situation, but again, let's break this down. So if he was offered 8 or 10 weeks pay after 25 years of service, that is nonsense. You're scoffing, as you should be, because that's not even close. So the factors that go into assessing how much severance someone is owed is age, position, and length of employment. And after 25 years, he'd probably owed closer to 2 years pay, probably from 18 to 24 months of pay. So if they offered him to 8 weeks or 10 weeks, that's a wrongful dismissal. That's not even, to say it's pennies on the dollar is an insult. It's that bad. Now, beyond that, the unfortunate thing is if, in fact, he, as I understand, he actually signed off on it, he gave up his rights. And that's the unfortunate thing. Can you imagine, instead of 24 months pay, they gave him 10 weeks pay, not knowing any better, he signed off on it. That's a terrible situation. That's a situation you don't want to ever have to be in. Once you sign off on that severance letter, you're stuck. You can't go back. You can't change your mind, even if you felt the pressure. It's understandable that you'd feel the pressure if you've been let go, but once you sign, you are stuck. Now, what could he have done? Well, he obviously could have called me, but he could have also gone to the severance calculator. It's severancepaycalculator.com. We'll talk more about that in a sec. But what I've done then is I've taken his information, I've plugged it into the severance calculator to show our viewers what would have happened if he had gone to the severance calculator. So after 25 years of service, let's say he's in his 50s, he was offered 10 weeks. Severance calculator shows us he would have gone 20 to 24 months pay. Right there. So if he had done just what I did, which takes seconds, if he had gone to severancepaycalculator.com, he would have known, wait a second, they're saying 10 weeks. This tells me at a minimum it's 20 months. We got a problem here. Unfortunately, he didn't know any better. Most people, many people don't know any better. You know better now, so don't let that happen to you.
I almost, I hope he's watching, but I kind of hope he's not watching after seeing that, right? That's huge. That's a really bad
It
number.
is, and it is a tough news for me to break, and I have to break this news to people often because they realize, wait a second, I was let go 6 months, 12 months, whenever it was ago. I signed off on that package. I understand now they owe me another $65,000. Can I do something about it? Can't do anything about it if you sign. So when do you get advice? When do you call me? When do you go to the severance calculator? As soon as you're let go.
You bet. Severancepaycalculator.com is the place. A lot of misconception when it comes to maternity and maternity leave. So we kind of put together for this show a maternity leave true and false. So I'm going to run through some of these, and you can say true or false. And
No,
tell us
we're not going to do that, John.
Okay.
We are not going to do that
this way,
today.
are we?
We're going to do it the other way. I am
shot.
going to be the interviewer for this time.
Okay.
I'm going to ask you. So we're going to do some true and false here about maternity leave. And you should really be able to get these easy. But a lot of people don't know. And so this is not about you, John. This is about our viewers. So I'm going to ask John here some questions about maternity leave. He's going to say true or false, and then we'll elaborate about it. So stay tuned, because I want to make sure everyone understands. This is a very important topic. Employers get this wrong. Employees get this wrong. So the first thing I'm going to ask you, John, is this. If a woman is pregnant and she's pregnant when she's accepting a new job offer, does she have to tell her prospective employer about the pregnancy?
Absolutely not.
Absolutely not. False. That is completely false. One for one. We're doing well here.
That's
we should quit while you're ahead. No, the reality is, if you're pregnant and you're being interviewed, if you're pregnant and you've just accepted a job offer, you do not have an obligation to tell your employer that you're pregnant, that you're going to be taking maternity leave. That's private. That's your personal information. Your employer doesn't have a right to ask you about that, by the way. If they do, that's a human rights violation right there. So it's none of the employer's business. You even if you know 8 months from now, 7 months from now, you're going to be off on a maternity leave, you do not have to tell your employer when you're being interviewed, and anything short of that is completely unacceptable.
You can offer up the information. Not sure you want to, but you can if you'd want to.
I don't know that I would, but certainly you could, but you don't have to, and you can't be asked. And beyond that, if later on the company realizes that you were pregnant when you were being interviewed, they absolutely cannot penalize you for not telling them.
Right.
That's the key.
Yeah. Okay. One for one. So far, I'm
one for one.
better than I ever did in school.
God help us all. Okay. Well, let's ask another one. So, true or false, John? An employee cannot be disciplined if her performance suffers because of her pregnancy.
True.
That is true. That is very true. So sometimes pregnancies don't always go smoothly. Sometimes we may have some medical issues that may impact us, and our job performance may deteriorate. Maybe we can't work as long, work as hard, do the job for the way we want. And if it's tied to the pregnancy, we cannot be penalized. The woman that can't do the job the same way has to be accommodated if it's tied to her pregnancy. Now, if it's unrelated to her pregnancy, if she decides she's not going to show up for work, nothing to do with pregnancy or slack off on the job, yes, you can be penalized and can be disciplined, but it cannot in any way be tied to your pregnancy if you get disciplined.
Maternity, true or false? I am in the hot seat.
Next one, John. True or false? The employer can hire a replacement for the employee who is going on a pregnancy or parental leave.
While they're off, I'm going to say yes.
That is true.
Yep.
So an employer does have a right to continue running its business.
Sure.
And that may mean bringing in a replacement for the employee. So an employer that hires a replacement is not doing anything wrong. But the key here, John, the key here is that does not mean that the person on maternity leave doesn't have a job. When the maternity leave is done or the parental leave is done, the person still has a right to their job. It's the employer's decision how they deal with the new employee they hired, but the employer can hire a replacement in the meantime. But again, the employee maintains their job while on maternity leave.
Same job as they had when they left.
Same job,
Okay.
same pay, same compensation, same everything, same location. Anything short of that is illegal. It's a human rights violation. It's an employment standards violation. But an employer can hire a replacement.
By the way, 1-855-821-5900, anytime, help at employmentlawyer.ca to reach out and contact Lior. We're talking maternity, true or false. This is important stuff here.
So continuing from where we left off. So if the employer likes the replacement better
Yes.
than the employee that's on maternity leave, the employer can just return the employee to a different position. True or false?
I'm going to say false.
It's absolutely false. So, and it happens often. The employer realizes we like the replacement better, so we're going to keep the replacement and bring back the old employee to a different position. Can't do that. The employee has a right to the same job, same location, same duties, and the employer cannot keep the replacement instead of them. That's illegal. There's not even a question about that, John.
Can they, if the employee that was pregnant comes back from a maternity leave, can they offer her? Say, look, no offense, but this person's really good. Would you mind going to? Can they offer a different position?
Sure. An
I have
employer.
a Casio. Right.
I like that. I like that reference. Planes, trains, and automobiles.
That's it.
Yes.
Yeah.
But they can offer, but certainly I think that puts also the employee in an awkward position.
Right.
So I don't think that is a good strategy. The employee that's off on maternity leave may feel obligated, may feel the pressure. So as a practical matter, I would say no. I would advise employers not to do that. Just bring back the employee to the same position.
I've got them all right so far.
So let's do one more. Assuming the employer needs to terminate an employee on maternity leave for legitimate reasons, the employer can let the employee go at any time while she's on maternity leave.
False.
That's false.
Yeah.
So here's the thing. Let's assume, John, that the employer knows that I don't have a job. Legitimately, the department shut down,
yeah.
whatever it is. I don't have a job for the employee on maternity leave. But she's still going to be on maternity leave for another 6 months, let's say. The employer should wait to terminate because you don't know what's going to happen 6 months from now. Maybe 6 months from now, you still need the person or you're going to need them desperately. You don't know that. So you can't jump the gun. All right? Your obligation is, as the employer, is to take the employee back after maternity leave. You can't actually assess your ability to meet that obligation until the end of the maternity leave. So if you've been let go early in your maternity leave, even if it's the reason is legitimate, that is improper. That could be a violation of the Employment Standards Act right there. Give me a call if that happens. And John, you got them all right. I'm speechless.
See, Mom, I did okay. This also applies for the fellas, too. Paternity leave, same thing. Same
so
thing, right?
if you take a parental leave, paternity leave, maternity leave, anytime you're off work for those reasons, you have the same protections, the right to your job, can't be punished, can't be penalized in any way. Anything short of that is not even close to being acceptable. And if that happens, please do give me a call.
And that number, 1-855-821-5900, help at employmentlawyer.ca. We'll take a short break, and we mentioned a couple times we are going to get into the Severance Pay Calculator as soon as we come back on Employment Hour 30.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. We've talked about it a few times already in the show. We'll get to it in depth now. SeverancePayCalculator.com.
Well, John, you and I started doing a radio show some 5 years ago, and we did that out of an idea I had. Let's inform people. That was the idea. Let's inform people so that there's no misconceptions anymore. People were calling me every day. I've been practicing for 15 years. People were calling me every day because they've accepted severance that was inadequate. They wanted to know, and it was too late to help them, and I wanted to try to get ahead of that problem. Yeah. And one of the ways I've done that is I've created the Severance Calculator. SeverancePayCalculator.com is the address. Again, SeverancePayCalculator.com. And what does it do? Well, the name tells you everything. The calculator helps you find out how much you're owed if you lost your job. It's simple, it's easy to use, it's completely anonymous. You don't have to put in your name. You don't need a credit card. Even if you had a credit card, there's nothing you could do with it there. It's only there for your information. And by the way, if you think you know how much severance you're owed, if you think it's a week's pay per year of service or 2 weeks pay, it is not. If that's what it was, I wouldn't have needed to create it. So you go to SeverancePayCalculator.com, answer a few questions about your age, your position, and length of employment, and you find out exactly how much you're owed. And you don't have to have a severance letter in hand to use it. Maybe you're just curious. You want to know, hey, what happens if the business gets sold and I lose my job? What would I get? Or maybe you're concerned because your boss is not treating you properly and you're reading the writing on the wall. You think they're going to let you go. Be prepared. Go to SeverancePayCalculator.com. You know what, John? I bet you anyone watching us right now, if they put a number in their head in terms of what they think they're owed, that number is going to turn out to be completely wrong once they actually go to the severance calculator. Go right now, SeverancePayCalculator.com. Let me know if you have any questions. And if you need to contact me, there's a button right there. You can reach out to me. Only if you want to.
Otherwise, completely anonymous. I'll get to a scenario and let you expand on it. Sean, 43-year-old worker as an IT technician for a mid-sized software developer. After 16 years with the company, he was fired due to unexpected market changes. Guess it happens, based on his $57,000 salary. His boss believes that 16 weeks of severance pay is quote-unquote acceptable, but Sean has only 2 days to accept the offer before it disappears. Should he take it?
And this scenario is based on a real situation, someone that called me, and so that's why I picked it, because it's a common situation. And some people may think, yeah, 16 years, it was offered 16 weeks, it sounds
a week per
right.
year.
Well, spoiler alert, it's not even close. But let's see how you could have found out on your own, and this person, Sean, could have found out on his own. Go to SeverancePayCalculator.com. What does it show us? Well, Sean is an IT, 16 years, $57,000. Severance Calculator shows us he gets 16 to 20, but months.
Yeah.
16 to 20 months. He was offered 16 weeks pay. Now, depending on his compensation, that could be a difference in the 6 figures. So that's a huge difference. So that's why the severance calculator is so important. In this situation, a very common situation, I'm going to say that most people that lose their job are going to find themselves in this situation where they're offered a lot less than what they're owed. So go to SeverancePayCalculator.com, find out what you're owed, and by the way, do the same thing for your friend and your family members. If they lost their job, go to the severance calculator for them, tell them to go to the SeverancePayCalculator.com website, make sure that they don't accept inadequate severance.
You know, I noticed at the bottom too, he says he only has 2 days to accept the offer before it expires, before it disappears. Come on.
Yeah, well, John, pretty much every severance letter is going to have a deadline. 2 days is pretty nasty. Sometimes it's 4, 5, 6 days. But regardless of that, here's the important thing, and I'm glad you raised it. That deadline means nothing. Your legal rights don't expire in 2 days, 3 days, 7 days. In fact, you have 2 years to pursue those rights. That deadline is a pressure tactic. That's all it is. The company wants the individual to think that, hey, if you don't accept it, you're going to lose something. Yeah. Well, in fact, they're offered a lot less than what they should be offered. So don't worry about that deadline. You have my permission. I'm right here on TV saying it, so no one can say that I'll deny it. You can ignore that deadline. Take the time you need to understand your rights. Call me if you want to. Go to the Severance Pay Calculator website. Make sure you know what you're getting.
SeverancePayCalculator.com. Check it out while we sit here and do the remainder of the show. It is EmploymentHourTV.ca. That is where you want to go, another website, of course, your website. You can find there a place where you can catch one of our radio shows in Ontario throughout the week as well. We take a ton of phone calls, of course, on the radio show. It's a call-in show. We like to play them back and get some feedback. We'll get to a call now.
I use to work as a temp, general labor in a warehouse. After a year working at a certain company with a certain agency, I was told, thanks very much, you've done a great job. And then I didn't get another shift, and that was the end of that gig. Is there going to ever be any legislation for temporary placement workers?
Great question. Very good question. And oftentimes you see all kinds of titles that may confuse people. Temporary, part-time, on contract, etc., agency. And a lot of people think that that somehow changes the analysis. So I'm going to make it as clear as I can. If you have a job and you lose that job, you're owed severance. It's as simple as that. It doesn't matter if you're a temporary employee, it doesn't matter if you're a contract employee, it doesn't matter if you're working through an agency. You cannot lose your job without getting that severance, unless, of course, you did something horrible. Now, if by temporary employee, that means that you signed an agreement that has an end date. So maybe you signed an agreement that you're going to work for 6 months.
Sure.
And after 6 months, they say the agreement has ended, we wish you all the best. Then no, in that situation, because the deal was, I work for 6 months, you don't get severance. But if they let you go before that end date, you may have to get paid till the end of the contract. If the agreement continues beyond that and you don't sign a new agreement, and at some point you're let go, you get severance. So in almost every situation, temporary employee, part-time, full-time, contract, whatever, you get severance if you lose your job. And if you're not sure, well, that's when you give me a call. Don't make assumptions. I really want our viewers not to make any assumptions. Well, I'm pretty sure in that situation I don't get anything. In most cases, those assumptions are incorrect, so call me.
So you're telling me if you're on a 3-year contract and the contract expired on Friday, you still go into work on Monday, now you're an employee?
Yes. It's exactly right. If you have signed a fixed term agreement, the agreement expired the next day, if you're still working in there, now you're a regular indefinite employee. And that's important for many reasons. One of them is if you are let go at that point, now the company can say, well, wait a second, we have this contract. You don't have a contract at that point. You get severance like any other employee.
Based on that 3 years prior?
Based on the full amount of service. So that could be months and months of severance. So, you know, the law here is in favor of the employee. The law wants to help employees. So if you're not sure how it helps you or if it does help you, reach out to me.
1-855-821-5900, help@employmentlawyer.ca. We'll take a short break, and when we come back, we'll talk about severance for restaurant servers. This is important as well. It's coming up, Employment Hour in 30.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back to Employment Hour in 30, and we got lots of phone calls come through in our radio show. You want to find out where that happens, just go to employmenthourtv.ca, all over Ontario. Several times during the week, people call in, they want to get the information. You answer the phone calls, answer the questions. We'll get to another one, and I'll have you comment on it, Lior.
I've worked for a company for 10 years. I'm 61. I'm a server. We were given written working notice. We will no longer be employed. I was just wondering if I'm entitled to severance, or am I working for my severance now?
So that's a very good question. So let's start with the idea that if an employer does give you notice, that notice counts towards your severance. Now, for that to be effective notice, for that to count towards your severance, it has to be in writing, of course, and it has to have a definitive end date. So you can't be told at some point in the next 6 months you're done. You have to be told on July 17th, whatever the date is, you're going to be gone here. And that period of time, that notice counts towards your severance. But the key to understand is just because you got notice doesn't mean you don't get severance also, because you may have gotten insufficient notice. So if someone is owed, let's say, 12 months of severance, one of the ways the employer can meet that obligation is to give them 12 months notice. But what happens if the employer gives only 5 months notice? Well, they still owe the employee that extra 7 months on the back end of it. So because of that, it's very important to understand what you're actually owed. Now, this particular person that called us, we played that call back from one of our radio shows. So she's in her 60s. She worked as a server for 10 years. She's probably owed 12 months of notice or severance. And how can she find that out herself? Well, she could also go to severancepaycalculator.com, and she put in her information there, and you see right at the bottom there that she gets 12 months of severance. Now, I don't know how much notice she got. So whatever notice she got, whether it's a month, 2 months, 6 months, that comes off the top of the 12 months. Right. But the company still owes her the balance. So if you get notice, that does count. It is what it is. The law says the employer can give you notice, but the fact you got notice doesn't mean you got enough notice. You may still be owed severance at the back end.
12 months would be quite a lengthy notice period.
It's unlikely.
That would be tough to have an employee hang around for 12 months knowing that their end of the line is a year from
Most
now.
of the time when I see notice, we're probably looking at a few weeks, maybe a couple of months.
Right.
And then at that point, the employer has to pay the employee the balance of that notice, and that could be very significant. The key also to understand is if you resign before the end of that notice, then that's a resignation. Cool. You don't get that extra severance. So you always want to understand what you'd be owed at the back end of it.
1-855-821-5900 is the number to reach Lior, a member of the team at the firm. There's also another resource for you called terminationquestions.com. You can ask your questions. There's a drop-down menu. Lots of questions have been asked and answered. I'll get one and I'll read it out for you here, Lior, from that particular website. You can expand on it. The company is shrinking the size of my sales territory. They said I underperformed last year and have to work harder if I want to gain my old territory back. This change is going to hit 40% of my commissions. Can they do this?
No, they cannot do this, because what this does is it now changes the person's compensation. So if the company wants to realign territories, change compensation structure, change commission structure, if that impacts the person in a negative way, that could lead to a constructive dismissal. Even if the company has the best intentions or good reasons, and there's good business reasons as to why they're making this realignment, this change, it doesn't change the reality that if it impacts the employee, if it impacts them negatively, they can treat that as a constructive dismissal. So for those that have not heard this term, what is a constructive dismissal? Well, constructive dismissal happens when the employer engages in or tries to make a significant change to the terms of employment. That could be change to your compensation, a demotion, a relocation, taking away commission. Any change like that gives the employee the option to treat employment as being terminated and get severance. It's as if the company let the person go. So in this particular situation, the one that you just read out loud here, the person would have the option. If it's going to impact them by 40%, that's huge. That's massive. They could accept it, or they could treat their employment as being terminated. The problem with accepting, of course, John, you know this, is once they've accepted, they've given the company the right to do it again. And then the next time they reduce it by another 40%, they won't be able to do anything about it. You only have one kick at the can when it comes to constructive dismissal, so don't miss that opportunity.
Would the same thing apply for a shift change? You're working in the same place, same job, same pay, but you're going from days to nights or nights to afternoons. Would that apply?
Oh my gosh, a change like that is massive. It's another massive change. If I used to work days and now they say I have to work nights or afternoons or what have you, that's a big deal, obviously. People plan their lives around when they work. So if I'm now going to be made to work a different shift, it's one thing if I was to work 9 to 5 and now it's 8:30 to 4:30. Sure. That's not a big change. But if I work 9 to 5 and I'm going to work 3 to 11 p.m., that's a big change, which means the employer can now face a constructive dismissal situation. I don't have to accept that change, even if the company has a good reason. And I can choose to treat my employment as being terminated, and the severance that you get is the exact same severance you'd get if the company let you go. You can go to severancepaycalculator.com to find that out. It's not something a company is allowed to do.
Lots of information every show. If you want to catch up anytime, the phone number 1-855-821-5900. EmploymentHourTV.ca. There you'll see a website where you can find our radio shows that happen all week, all over Ontario. And of course, email is help@employmentlawyer.ca as well. Till next time, this has been Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.